Arguments this morning with the state of Ohio versus Andre Sanford. It's case number 18CA011308. We've read the briefs and are ready to proceed if you are.
Thank you, Aaron. I would reserve my full time for rebuttal.
5 minutes?
Yes, the whole 5 minutes.
Okay.
Good morning, Aaron. May it please the court. Giovanna Bremke on behalf of Mr. Sanford. And I know you have read the briefs, so I'll make the facts brief, but Mr. Sanford was initially charged with failure to stop after an accident. He was in an accident with a motorcycle, fled on foot, but turned himself in within an hour to the police station. The gentleman in the motorcycle did pass away. There's set through 4 assignments of error. The first is the Rule 11 violation based on the Kubison case, which I realize this court has reassessed in the White case recently. So I'm not going to spend too much time on that, although I would again ask that you reassess that matter because there wasn't a plea by Mr. Sanford. There was just a plea entered by his counsel. Second assignment of error, and this is speedy trial issue, and quite frankly, this case is, in my opinion, the textbook example of a speedy trial violation, and exactly the reason why we're all here to get checks and balances. This case, he was originally charged at the municipal level with a failure to stop, but then was indicted later with additional charges. There's no question that he was in jail for 95 days, which is equivalent to 285 days for speedy trial calculation purposes. There's no dispute on that. There's nothing that told the time. It's a very clear-cut violation of speedy trial. The issue is whether those additional charges relate back to the failure to stop. The additional charges, with the failure to stop, ended up being count 3 of the indictment. It was a 7-count indictment. The trial counsel filed a motion to dismiss, and 3 of those charges, and what I'm going to say are the menial charges, the failure to stop, the driving under suspension, and driving without a valid license, were all dismissed and left us with the 4 significant charges, 2 OVIs and 2 ag vehicular homicides.
So he was originally arrested in October of 16 and charged with failure to stop?
Yes.
And when did the indictment issue? What date do you know?
The indictment was in December 29th of 2016, and
that was a 7-count indictment.
7-count indictment. And what happened, and to give you some procedural history, what typically happens is very common and maybe not proper, but also not challenged, is that the grand jury prosecutor will go to the judge and say, I ran out of time, give this guy a personal bond. That's what they attempted to do in this matter, but for whatever reason, the jail, and everyone was under the impression that he was going to get out, and the jail didn't receive the paperwork, and he never was released. It was right around the time of the holidays. He was never released until when he came for his arraignment, and everyone said, oh my gosh, he's still in. Then he was released at that point on January 9th, which was, again, 5 days past his 90 days and 15 days past his 270 days. So again, clear-cut violation. The OVI, actually at the time of his arrest, when he turned himself in, he admitted, I smoked 2 blunts and marijuana, and he admitted, that basically in the entire scenario that he hit the driver. At that time they knew the driver had passed, or right around that time they known the driver had passed. And actually, most significantly, the officer read him the BMV 2255 form, and in the first line of that form it says, and he testified, I read him, and directly from this form it says, you're under arrest for OVI. Then what the state relies on is this Baker case, which was also adopted through the 9th in the Overholt case. The same reasoning was adopted. That if you knew about the facts at the time, if it's new facts that were learned later, it doesn't relate back to those original charges. The OVI, I don't see how there's any dispute that they didn't know that they could have charged him with the OVI. They read him the 2255 that says you're under arrest for OVI and just didn't charge him. You look at his bond, it's not a bond for failure to stop. It's a very high bond. Quite frankly, they knew these other charges were coming. They knew of the facts. and just completely messed up in keeping him in the county jail, which is exactly the reason we're here. It is exactly what speedy trial was formed to do. It's a constitutional violation, and both of those OVIs relate back. There's also extensive case law on how that per se violation relates back. After the filing of these briefs, and it was about a month ago, late April, the 8th District also came out with a case which is very much in line with what this case is. It's the Busick case. And again, their proposition is that in that case, they were waiting on lab results to come back for Percocet or oxycodone. But she said she had admitted, the defendant in that case had admitted to using it. So they said that you don't know, you're waiting on your lab results, but you knew about that use because by way of admission. And again, Mr. Sanford admitted to the use in this case at the time of his arrest. He was extremely cooperative. And of course, the ag vehiculars, they relate back to the OVI, but also the death they knew about immediately. The gentleman died essentially right away. There was no holding period. They knew of his passing. And again, if you look at the transcript, page 6, there's some argument about this speedy trial issue. There was a whole hearing on it. But again, the trial counsel does a great job at saying that all the facts were there. In fact, he says they sat on it, they didn't bring it in a timely manner, and I completely agree. It was no new facts. They knew that the guy had passed. Mr. Sanford admitted to the smoking. The state also says, well, this is, and the case law says, this Baker rule was meant for complex and elaborate cases. The Baker case, there was financial records that took a long time to review. It's a serious case, and it's a sad case. It's not an elaborate case. The gentleman died that night. Mr. Sanford admitted to smoking marijuana, and all of the knowledge was there on that night.
As I recall, they did a blood test on the defendant, is that correct?
They did a blood test on the defendant, and that goes into the suppression argument, which was also argued. The blood test was drawn outside of the 2-hour window. So, but just for sake of saying how short this time frame was, although Mr. Sanford did run, he turned himself in within an hour, and they did a blood draw shortly after the 2-hour window. So they knew all of that information, and again, all of those statements were within 2 hours of the accident. So within 2 hours of the accident, they knew everything that they would have known at the time of the later indictment. The suppression is based on several issues. One, there was testimony from Officer Garvin, who's the one who read the 2255 form, and also Detective Sumter. Both of them testified they didn't see signs of impairment. Nevertheless, they drew the blood. There's the Birchfield case, which stands for the fact that these additional consequences, losing your license, being charged with a refusal, increased penalties, all of those would take into question the consent of a blood draw. And the fact that it's different than a breath test because drawing blood is much more personal, much more invasive to the body. But they did draw blood in this case. The Birchfield case is fairly new. It's an Ohio Supreme Court case, U.S. Supreme Court case. They drew the blood without a warrant, although the state is claiming that there was consent, although Birchfield case would imply that he was without authority to consent. It's also, and I previously stated this, outside of the 2-hour time frame, and there was extensive testimony, and I outline it in my brief, from Officer Garvin, I believe is his name. He talked about how he read this 2255 form. He says, you're under the arrest for OVI. They never charged they didn't charge at that time with the OVI. He actually certified the form, signed it saying, I'm certifying that I'm arresting Mr. Sanford for OVI. And that blood draw again was outside the the time limitations.
I'm gonna pause right now, only to let you know, your total time is 5 minutes and 18 seconds, so 18 more
Right.
seconds you'll be in here.
Okay. Let me briefly touch on the disproportionality argument, which is the fourth assignment of error. And again, the law in this case says that if there's a three-part test, but essentially if the disproportionality sheds a shock into the sense of justice in the community, these cases, these ag vehicular homicides, this community in general is just screaming with shock at the disproportionality. And all of these cases, and again, there's the Adriana Young case, which was extremely controversial in the community, and she was given 4 years, and obviously the significance of that is she can receive judicial release, and she did after 6 months. And then also the Chase Johnson case, both of these are marijuana, same as Mr. Sanford. Both of them ag vehicular homicides. Chase Johnson was prom night, a girlfriend in the passenger seat. She dies. He does not serve 1 day in jail. He gets 5 years of community control. The disproportionality it's shocking in this case. Mr. Sanford serving 8 years, no chance at judicial release until he can get out, and after maybe 7 years or so, but no chance within that first 5 years for judicial release. He is, and it's throughout the record, it's clear, at the time, the night of the accident, he was crying so hard, so sympathetic that he couldn't even hardly articulate himself. In the sentencing, again, he's very remorseful. I can tell you in person, he's very remorseful. This is something that is extremely, again, shocking, that the disproportionality of these same exact cases, marijuana, ag vehicular homicide, and someone passed away. I'll reserve the remainder of my time.
All right, 3 minutes and 12 seconds then for rebuttal. And you'll have 15 minutes. Counsel.
Good morning, Your Honors. May it please the Court, Lindsay Poprocki on behalf of the State of Ohio. As counsel has indicated, the heart of this appeal centers on the trial court's decision to deny 2 of appellant Andre Sanford's pretrial motions. First, the denial in part of his motion to dismiss for lack of speedy trial, and second, the denial of his motion to suppress. The state would submit that the trial court's denial of both of these motions was proper and should be affirmed. With respect to Sanford's motion to dismiss for lack of speedy trial, because the indictment in this case rested on facts that were discovered after Sanford's arrest, and Sanford could not have been charged with violations of the OBI laws at the time of his arrest, the state would submit that the statutory right to a speedy trial did not elapse, and the trial court properly denied his motion to dismiss.
Okay, counsel. I realize you weren't a part of the trial court, so I don't want to kill the messenger here, but
Okay.
said the indictment rested on facts that were discovered later, basically the blood test results.
Sure.
As I read the indictment, unless I'm incorrect, one of the ag vehicular assaults was not merely, it's a big deal, but causing the death with recklessness. How did that rest on the blood test results? And I would ask the same question as to the A1 OVI.
The A1 OBI in count 1, the agricultural homicide?
No, just the straight misdemeanor OVI,
Okay.
because he's got 2 ag vehiculars.
Agricultural homicide in count 1. Okay. Can I just answer that question first?
Sure.
Count 1, would I say
Any way you want.
rested on the per se violation in count 7 of the OBI violation, and count 2 recklessly. I think in the motion in opposition to the speedy trial motion, the state even conceded that the argument of the defense might have merit as to count 2.
Okay, fair enough.
Okay,
Thank you.
but the trial court did keep count 2 intact.
Okay, thank you.
Sanford was arrested on October 6, 2016, and charged solely with failing to stop after an accident, which was a felony of the second degree. And a blood test was taken, and the toxicology reports, which gave the results of Sanford's blood test results, was not received until November 14th of 2016. Those results indicated that Sanford had prohibited concentrations of THC in his blood, the finding that permitted Sanford to be charged with per se violations of the OVI law. The 7-count indictment was returned on December 29, 2016, and Sanford was subsequently arraigned on January 9, 2017. And because Sanford had been in custody from the date of his arrest until the date of his arraignment, the motion to dismiss on speedy trial grounds followed. But because Sanford was not charged with, nor did the state have the facts to support several of the charges in the indictment at the time of his arrest, the speedy trial clock did not begin to run until his indictment in this case. Because the toxicology reports were not available until much later, the state could not bring any charges for the OVI violations for per se based on the presence of THC, the fact that allowed the grand jury to indict Sanford on the first 6 and 7 counts of the indictment. Because Sanford faced certain charges which were based on evidence not known at the time of his arrest, they became subject to a new speedy trial calculation, which follows the general rule set forth by the Ohio Supreme Court in Baker. Here, the receipt of the drug testing results in November supported a new speedy trial clock on the later filed charges and of the per se violations of 4511.19. In his brief, Sanford relied on a first district case, State v. Cooney, where the court found that the speedy trial time started at the time of the initial OVI charge, even without the blood test results, because they were simply proof of what the state had already known or should have known. And that's basically what Sanford's arguing here today. But Cooney has been criticized in State v. McKinney, which was cited in the state's brief. In fact, McKinney cited to a case, State v. Muhammad, for the support of several appellate courts who have all held that a subsequent indictment, which was dependent upon a lab analysis that was not available to the state at the time, starts a new speedy trial clock. McKinney, in fact, involves circumstances very similar to the case of Barr, and that the defendant was not charged with OVI per se until after the lab analysis was completed to show that he had prohibited amounts of marijuana in his blood.
So theoretically, if it took the VCI lab 2 years to get the test results in, speedy trial time wouldn't run until that person had served 2 years in jail. Theoretically. That's the argument.
I hear what you're saying.
I mean, that's what you're saying the law says, and McKinney and Mohammed would support that.
Theoretically, I suppose, that's the holding of McKinney. We would submit that the December 29, 2016 indictment returned by the grand jury in this case contained the first charges based on new evidence. And under Baker, a new speedy trial clock for the offenses tied to the later investigation and lab reports in this matter started the new speedy trial clock, and the motion to dismiss on those counts, the later filed counts, were properly denied. As to Sanford's motion to suppress, the state submits that the trial court also properly denied that motion on alternative grounds. First, the trial court properly determined that Sanford was never placed under arrest so as to trigger the 2-hour time limit contained in the implied consent statute. In the alternative, the trial court properly determined that even if Sanford were under arrest, the state substantially complied with the 2-hour time limit under the implied consent statute based on the court's reasoning in State v. Slates. In its motion to suppress, Sanford challenged the timeliness of the blood draw and asserted that it was taken outside of the 2-hour requirement of the implied consent statute, which it requires an OVI arrestee's blood to be drawn within 2 hours. However, the plain language of the implied consent statute makes clear that the police can only use such implied consent after the person has been placed under arrest for driving under the influence. Here, the trial court agreed with the state's position that because Sanford was never placed under arrest for the OVI offense, the implied consent provisions of the statute were never triggered, and the time limit for drawing the blood by consent was the 3-hour time limit set forth in the general OVI statute. While it is true that Sanford was read the BMV 2255 form, a valid arrest must precede the seizure of a blood draw and must precede implied consent given by the form. Generally, 4 elements must coalesce before a valid arrest under Ohio law. Those include an intent to arrest under real or pretended authority, accompanied by some sort of actual or constructive seizure, so that the person understands that he or she is not free to leave. Here, these elements simply did not exist, and Sanford's reliance on the mere reading of the BMV form was not enough to constitute an arrest. While appellate courts are divided on whether the mere rote recitation of the BMV form informing a suspect that he is under arrest is sufficient to imply an actual intent to arrest, at least some courts have held that that recitation of the BMV 2255 form is not itself sufficient to constitute a valid arrest. Here, the evidence gleaned at the suppression hearing belies Sanford's assertion that he was placed under arrest simply because the BMV 2255 form was read. At the suppression hearing, Officer Garvin testified at the time he was directed to complete the form, he did not believe Sanford was under arrest, nor did he take any steps to effect an arrest upon him. Prior to reading Sanford the form, Sanford was not placed in handcuffs, nor was he placed under arrest by Officer Garvin. And Officer Garvin did not personally file any charges against Sanford. Consistent with Officer Garvin's testimony, the trial court concluded that Sanford was never placed under arrest. Specifically, the trial court concluded, based on the testimony of Officer Garvin and Detective Sumter, who subsequently advised Sanford that he was not under arrest, that the form simply advised Sanford that he was under arrest for driving under the influence. In addition, the trial court noted that no arrest-related activities took place, and that Sanford was not placed in handcuffs, that his movement was not limited in any way, and within a short time, he was advised by Detective Sumter that he was not under arrest. Under this court's standard of review on a motion to suppress, the trial court is in the best position to determine witnesses' credibility, and its findings of fact were supported by competent and credible evidence.
Does that mean that Mr. Sanford could have just walked away from the officer after he read him the BMV 2255? Since he wasn't under arrest? Is he free to leave at that time? Or is that not the appropriate standard?
I don't think he was free to leave, but the 4 elements must coalesce, and in this case, they didn't coalesce. There was no intent to arrest. I would say that the 4 elements didn't combine for there to be an arrest, but he was not free to leave.
Did he leave the hospital in handcuffs?
He was, after the interview with Detective Sumter, not after his interactions with Officer Garvin. He was subsequently interviewed by Detective Sumter, Mirandized, and then, I believe, arrested by Detective Sumter.
The distinction being that he was arrested for
Failure to
leaving the
stop.
scene at the accident, failing to stop.
Not OVI.
Got about 2 minutes left.
Okay, I'll just briefly address the fourth assignment of error, where Sanford asserted that his sentence was disproportionate to sentences for other cases in the Lorain County Court of Common Pleas and violates the Eighth Amendment's prohibition against cruel and unusual punishment. We've heard that Sanford's sentence was 8 years in prison for a first-degree felony, and we would submit that that sentence falls directly within the applicable sentencing range for a first-degree felony. Despite this fact, Sanford is still claiming that this was somehow a prohibition against cruel and unusual punishment. We would simply submit that that is just not the case. A sentence within the range allowed by a valid statute is generally not cruel and unusual. And as to the argument about proportionality and consistency with other aggravated vehicular homicide cases in this court, the state notes that Sanford did not challenge the proportionality of his sentence in the trial court, and he has waived that issue for purposes of appeal. You have to raise that issue in the trial court to give the appellate court some type of starting point for analysis for purposes of appeal. For those reasons, we would ask that the trial court's decision be affirmed. Thank you.
Okay, thank you. Council, you have 3 minutes and 12 seconds left.
Thank you. To address a few of your questions, there was actually testimony from the officer that Mr. Sanford was not free to leave the hospital. He did leave in handcuffs. Back to the speedy trial, and I want to point out again that 8th District case does a good job at talking about how there is, when you have this per se violation, but also you have an admission. So in those cases, there was an admission. Yes, I was, there's multiple cases that talk about an admission to the use of drugs and how that's not new knowledge even for the per se violation. And he said, yeah, I smoked 2 blunts earlier today. That's not new information. So even for, again, I think it's very clear on the A1A that it's clear that there's a speedy trial violation. But I also think it's clear on the per se because of his direct admission. And the lab results, and again, the trial court counsel, he says, this is every drug case that comes here. There's a suspicion of cocaine, but we wait for the lab result to see, just to confirm it. But when you have that suspicion that there was marijuana use and then also an admission, it happens all the time that the state charges on a possession, even when they're waiting for those lab results.
Didn't he also admit to having a couple shots, or am I confusing myself?
He did. He did admit to having a couple of shots. He did, but he's charged with the per se on the marijuana. I think he admitted to having 2 shots and smoking 2 blunts before driving. And again, extremely cooperative. And it happens all the time that the state charges and then waits for the lab results. And again, in the 8th District case, they go through a scenario where they waited a year for the lab result. This was similar to the scenario Judge Teodosio posed, where they waited a year for these lab results and then charged later, and that was thrown out, saying the trial court upheld it, but the 8th District overturned, saying that you can't do that. It's no new knowledge there. And again, a lot of that is based on admission, and he did admit in this case. Admission and a suspicion by the officer. There was clear suspicion. That's why they did the blood draw, and that's why they read the 2255 saying you're under arrest for OVI. There's no new facts that were discovered. Again, all of that was known the night of the incident. He admitted they had suspicions, and they knew that this gentleman had passed away. It's all information that related back to these, that related back to the initial charge. There was no new information there. Any questions?
So the 8th district case would not support a conclusion that time had run on it, on any charges other than the per se violation. Am I making, does that make sense to you?
No, I believe under the I believe the 8th district opinion would toss it all, even the per se. Again, because of that admission.
Is there a case law that would support that proposition that the per se violation was not a speedy trial violation because the test results hadn't come back yet?
I think
That charge alone.
right, I think the state cites to some of that. I would say the distinction with that is that there was an admission to smoking.
But smoking below a level.
Right, but it's still, again, this happens all the time where there's drug cases where we're waiting on lab results in the state. They have the knowledge. You know, what is knowledge? It's a very, in my opinion, a very low standard. That per se, again, can we wait 3 years for these lab results? And that's not uncommon with the State Highway Patrol to wait a long time on these lab results. Does that mean he can just sit and it all relates back?
Well, then you'd be looking at perhaps a constitutional violation and not a statutory violation. In other words, it wouldn't be just the triple time that you're talking about, it would be actual, looking at the constitutional violation in regard to the length of time,
Right.
whether it was reasonable or unreasonable.
Right.
And it may be regarded as unreasonable for a 3-year period. But that's kind of a different issue, isn't it?
In some regards, but again, where do you draw the line here? You know, so he can wait not 10 months, is that not necessarily a constitutional pre-indictment delay or whatnot, but, you know, it is, again, speedy trial.
But the reality is we've got 95 days here and nobody's disputing that.
Nobody's disputing. 95 days, which would be 285 days unrestricted.
Thank you for your arguments. Both of you will take the matter under advisement, issue a decision in due course. Of course, clerk of courts will mail each council a copy of the decision on the day it's released. And as you know, the opinions are also posted on the Supreme Court of Ohio's website. Thank you both again for your arguments.